Today is December 21st, 2023. It's approximately 10:04 a.m. This is the date and the time that is scheduled for the hearing regarding Highland Water Company Inc.'s request to update its service area in Docket 23-010-01. And specifically, we're here for arguments on the petition to intervene filed by Mountain Green Mutual Water Company and Village at Trappers Loop LLC. Everybody at the right WebEx hearing? Okay, and I'm assuming everybody can hear me okay. I just saw some head shakes. Okay. Wonderful. Why don't we get going and let's begin with appearances. So on behalf of the petitioners, please make an appearance.
Yes, Your Honor. Matt Jensen on behalf of Mountain Green Mutual Water Company and Village at Trappers Loop. I also have Tammy Frisbee here, who's another attorney in my office. The president of our irrigation company, our mutual water company, should be joining shortly. I think he got delayed. But happy to be here and explain our position on the petition.
Thank you very much. Before we go on, I want to note that we do have a court reporter with us today. Sorry, I'm trying to find. Oh, hi, Brooke.
Yeah.
So Brooke will be transcribing this just like if we were live and in person. I want to make sure everybody speaks loudly enough and also keeps a cadence or a pace that is amenable for Brooke to do her job. I did note, Mr. Jensen, I was having a hard time hearing you. It could be my speakers. It also could be my ears, but just try to speak a little more loudly for my benefit. If there is any issue with the conversation, the presentations, the questions, the answers in terms of being able to be transcribed, I'm giving Brooke carte blanche to interrupt us. So Brooke, please do that as appropriate, and nobody be offended if she does. We want a good record here. With that being said, thank you for your appearance, Mr. Jensen. Welcome, Ms. Frisbee. Why don't we go to Highlands? Who is here on behalf of Highlands?
I'm Marjorie Smith, president of Highlands Water Company. This is Bart Smith. He is also an officer in our company. And this is Nate Hadley on my left, and he is our operator.
Okay, thank you very much. Ms. Smith, I'm going to ask you to maybe get closer to the microphone. I really had a difficult time hearing you.
Okay, sorry.
That's okay. No, this is no fault finding here. Am I the only one who's having a hard time hearing folks? Because if y'all are hearing just fine, I need to make some adjustments on my end, which may have been what I was dealing with this morning. Was Mrs. Smith clear enough for everybody, loud enough?
I could hear her, Your Honor.
Okay.
You can hear Matt Jensen just fine as well, Your Honor.
I couldn't even understand that.
That was hard for me as well.
Oh.
I was sitting far back, but we can hear Matt Jensen just fine. So.
Okay, so for the HWC folks, since I saw that's how you're designated on your tile, I need you to be as close as possible to the microphone, and don't be offended if I ask you to repeat yourself because I'm not hearing you. In the meantime, give me 1 second and I'm going to check my speaker setting.
And Ms. Sims, can you hear me okay?
I hear you fine, thank you.
Thank you.
Okay, I kind of reset my speaker, so let's see if that works. I do want to note that I see some folks from the Division of Public Utilities that are attending this hearing. Folks, are you here as observers or otherwise? And Ms.
This is
Salter,
Brenda Salter. Sorry, this is Brenda Salter, and we are here just as observing.
Okay, thank you very much. And it looks like somebody just joined us via phone. They're identified as call-in user number 2. Please identify yourself.
This is Roland Gardner. Dwayne Johnson.
Okay, and Mr. Jensen, do you want to introduce those two folks?
Yes, Your Honor. So Roland Gardner and Dwayne Johnson are board members of Mountain Green Mutual Water Company. And also Roland is the principal of Village at Trappers Loop.
Okay, thank you very much. I'd like everybody to remember to mute yourself when you're not speaking. The drawback to that, though, is that you must unmute yourself when you want to speak. And that might actually be a good thing because we're going to go in order and we are going to let sides present their arguments uninterrupted, except for maybe by me, and I will do my best not to interrupt. So please mute yourself until you have the table to speak. Just the lay of the land for everyone's orientation. This is not unlike a normal court proceeding, which means that this is the petitioner's petition because they have the burden on this. They go first. They will present their arguments and will be subject to questions by me, nobody else. Then the opposition, or in this case, Highlands, you will have an opportunity to present your argument in opposition to the petition and anything else relevant to this petition. Then finally, and then I too will be able to ask you some questions. And then finally, we will allow again the petitioners to present, in essence, a reply to what they heard from Highlands' argument, and then be subject to questions by me after that, if any. And that would be the course of this proceeding. Any questions on that? Okay. Then I, at this point, will turn it over to Mr. Jensen. Please proceed.
Thank you, Your Honor. So as you alluded to, we're here for a single issue, and that is whether intervention is allowed in Highland Water Company's request to expand its service area under Utah Code Section 63G-4-207. That section provides that the agency shall grant a petition if two elements are satisfied. First, the petitioner's legal interests may be substantially affected by the proceedings. And second, the interests of justice and the orderly and prompt conduct of the adjudicative proceedings will not be materially impaired by allowing intervention. So that's what we're here to discuss. I'll first note that as to the second element related to materially impairing the proceeding or the interests of justice, Highlands Water Company has made no argument to the contrary. They've essentially conceded that point. So really all we're here to discuss is whether the interests of Mountain Green Mutual Water Company and Villages at Trappers Loop may be substantially affected by the proceeding. Now,
Can we have Mr. Nelson mute himself?
Yes.
Pardon me, Mr. Jensen, I apologize about that. Who
No
is Mr.
problem.
Nelson? Does anybody know who Mr. Nelson is?
It looks like he muted himself now.
Yeah. So, Mr. Jensen, you don't know who Mr. Nelson is?
I do not.
Ms. Smith, do you know who Mr. Jensen is?
He's a board member.
Nelson? Okay, great. Thank you.
Yes.
Apologies, Mr. Jensen. Please go ahead.
No problem at all. So in discussing whether the petitioner's interests may be substantially affected, it's important to note the one item of where Highlands responded to the motion for intervention, they say there's quote, no reason a mutual water company cannot coexist in the same service area as a regulated water utility company. And we have no qualms with that position at all. In fact, we think that's correct, that there can be overlapping mutual water company service in an area where a public utility, and we can get into that a little bit later as to why that's the case under the statute. However, I think it's important to recognize the history here. Highlands Water Company officers have stated the contrary position to the Morgan County Commission on multiple occasions, asserting that they were the only water company that could service this particular area. And I'll reference, Your Honor, Lee's Marketplace. That's kind of the specific project that's teed up right now and is currently under construction. There's been multiple board meetings or commission meetings before a Morgan County Commission on that, and Highland has come and given public comment suggesting to the commissioners that they're the only ones that could service that particular project. That was very problematic for us, and I think caused some confusion there. So petitioners want to make sure that we have a seat at the table and for this expansion to make sure that its interests are not undermined by continuing those positions. Second, despite conceding that point in its response to the petition for intervention, Highlands then claimed in its response, or I guess more accurately, its reply to our opposition to the expansion of their service area, stating that no exemption from Public Service Commission regulation is possible if it, quote, conflicts with or adversely affects the operations of an existing certified public utility. So there's a little bit of confusion in Highlands' positions here, and I want to make sure one of the reasons for intervention and one of the reasons why Mountain Green Mutual and Village's interests could be affected here is because of these contrary positions. I think it's important for Mountain Green Mutual to be involved in the proceeding so that its position on that point can be stated. Now, with respect to why that concession in the response is correct, as you look at Utah Code Section 54-4-25, it's clear that if a public utility is looking to provide service, they need to get a certificate of convenience and necessity. There is, however, some indication in the text of that statute itself that does not, a certificate of convenience and necessity, and I apologize, my light turns off if I don't dance around a little bit here and there, but a certificate of convenience and necessity does not provide exclusivity, even as against other public utilities. In fact, when you look at subsection 5 of that statute, it deals exclusively with a supplier of electricity that's seeking a certificate of convenience and necessity, and provides that once a certificate is provided for the electric utility, that provides the applicant the exclusive right to serve the customers. That's the only time in the whole code there where we talk about exclusivity. So that's correct as well. Now, the other thing I think that is important on that front is Mountain Green Mutual Water Company is applying for an exemption in a separate docket before the Public Service Commission because it does not serve the public generally. It serves only its shareholders. And Highlands has cited to a provision and also a statement in the application itself asserting that, hey, you can't get an exemption if there's a conflict with a service area of a public utility. And that is not supported by the statute. In fact, it comes from subsection 4 of that Utah Code Section 54-425. And in that, it talks about an applicant for a certificate of convenience and necessity must make a statement that it won't, let's see, let me just read it here so that I get it correctly. That it will not conflict or adversely affect the operations of any existing certificated fixed public utility which supplies the same product. So that also would not apply with respect to obtaining an exemption request. And so just wanted to kind of put to bed that concept and note that, yes, we agree that there's nothing that prevents the overlapping of service from a mutual and a certificated public utility. That does not, however, ameliorate the need for Mountain Green Mutual to be a participant in this service area proceeding, because there are other interests that are being protected from the petition for the petitioner in this proceeding. Specifically, Village is the owner of a property here. And one of the things that could be compromised by allowing expansion of the service area to cover this property is clarity. There's significant questions on whether there's capacity in Highlands system to service this area. We do know that Mountain Green Mutual has a active long-term lease that will ripen into ownership for a 1 million gallon tank and for 2 wells to service this exact area. We don't have anything. In other words, there's been significant investment on a mutual company basis to supply this area. And those are assets that, Highlands makes the argument, well, are those Cottonwood Mutual assets or are they Mountain Green Mutual assets? The fact of the matter is they are Mountain Green Mutual today, and there's no claim at all that Highlands has any interest in that infrastructure. And so it's important here for Mountain Green Mutual to provide clarity to its customers that if they need water service, their members need water service, it's going to be through Mountain Green Mutual. And ultimately, just so you're aware, Your Honor, there are discussions about teaming up, I guess, with Cottonwood Mutual that are still ongoing, as Cottonwood Mutual mentioned in its response to the expansion request. But as of right now, Mountain Green Mutual is the sole provider for this area and for its members, which includes Soderby and Village. Finally, in terms of the reasoning for intervention, to the extent that there are factual issues that need to be explored in Highlands' reply, I think it's very important that Mountain Green Mutual and Village be a party so that they can put on the evidence. I don't think there's any other party that is motivated or able to put on the evidence that has been disputed by Highlands. And so for those reasons, we would request that Mountain Green Mutual and Village be allowed to intervene in this proceeding.
Thank you very much, Mr. Jensen. I appreciate the presentation, and I appreciate your acknowledgement of the helpfulness of background. And because of that, I do have some questions for you that will relate to the background, but they are intended to address this substantial legal interest, I guess, prong. So let me just take it from the top. So Village is its own corporate entity, correct?
Correct.
Okay, so it exists independent of what I will call MGMWC.
Correct.
Okay, and if I mess up that acronym, I apologize. Okay, and then Soderby, who's referenced in various of the filings in this particular docket, is not a party to your petition, correct?
Correct.
Okay. And you just said that village, as I'm trying to understand exactly what the legal interests are, kind of check, check, check. You said a village is an owner of a parcel. Where is that parcel?
Thank you, Your Honor. I don't know if I'm allowed to share screen, but I think it might be helpful to look at a map as we look through that. Is that possible?
I'm not in charge of whether or not you can, if you're forbidden from, technologically speaking, from sharing. Why don't you give it a shot? Okay.
Was I successful?
You were.
Okay.
Let me just check with everybody. Ms. Smith, can you and your group see that map? Okay, thank you. And Brooke, you can see that? Okay, wonderful.
Okay, so this is a little bit. I mean, part of the reason we're here, Your Honor, is that it's a complicated map. There's a lot going on here, obviously, but the green here is what Mountain Green Mutual, the areas where they intend to serve their members as an exempt mutual water company. And the reason that that's the boundary is this area down here is owned by villages at Trappers Loop.
Okay.
Okay. Everything in yellow is owned by Soderby LLC. And just to explain the legal interests that are involved, Soderby LLC is an entity where Dwayne Johnson, who's on the phone here, is a principal of Soderby LLC. They're the property owner, and he's also a board member of Mountain Green Mutual Water Company. So there's essentially two members currently, or two shareholders currently of Mountain Green Mutual Water Company. One is Soderby LLC, and one is Village at Trappers Loop LLC. So again, everything in yellow and is Village, or is Soderby LLC, and then I believe actually they also own this piece here. Can you see my cursor, by the way, Your Honor?
Yes, I'm able to see it okay. I'm assuming everybody else can as well. If not, please say so. Okay, please go ahead.
Okay, and then, like I said, Villages at Trappers Loop is this section here, down in the southeast portion of the proposed service area for Mountain Green Mutual.
Okay.
Is that helpful?
That is helpful, and it does lead to another question, which is, why is Soderby not a party to your petition? If they're the owner of the yellow area, which seems to be smack dab in the middle of where the fight's currently kind of pitched?
Part of that is Your Honor, that I can't speak for them. I don't represent Soderby.
Yeah.
But what I will say is that I think their interests are adequately represented by Mountain Green Mutual Water Company.
Okay.
And second, because they have separate counsel.
Okay.
I think there was an interest in trying to avoid any sort of concerns between the members of Mountain Green Mutual.
Okay, that's thank you for that explanation. Sounds to me if they want to show up, they can try to show up at this point. Okay, so let me go back to my questions. And again, thank you. I think that orientation was helpful. We may need to double back. We'll see. So besides planning on, so I'm looking at your petition. And you're welcome to reference it. I'm doing it from notes, so if I do misquote, I'll try to make that clear. But in paragraph number 2, the petition states that MGMWC is planning on providing water to the project. What else, if anything, will that entity do with respect to the project?
Nothing else. Mountain Green Mutual is purely the water provider for the project.
Okay, thank you. And I'm assuming that could change if circumstances present itself down the road, but at this point, what you just said is the state of play, correct?
That is correct. And you know, by way of background, there's long been some discussion about creating a Mountain Green water district or special service district or whatever type of district. And there's certainly been discussions on that front. I know, you know, as we have been in discussions with the Division of Drinking Water, there is certainly a movement or a desire from Division of Drinking Water standpoint to consolidate things and avoid having lots of little water providers. And Mountain Green Mutual is not opposed to exploring those possibilities. And in fact, I think there's even been separate council engaged to evaluate how we might go about doing a district in the future. And those discussions have involved Cottonwood Mutual as well. So, you know, it's not a static situation. But as we sit here today, the only thing that Mountain Green Mutual is set up to do is provide water. And the area to which it's set up to provide water is this area that I showed that was outlined in green.
Okay, thank you. Okay, staying on paragraph 2, I want to know what the basis for the claim in that paragraph that Highlands has agreed it cannot claim as part of its service area, in essence, that area. So that assertion is that it can't claim that area at all. It's nothing about exclusivity. So what's the basis for the claim as I just quoted?
And it is entirely based on the basis of 2021 settlement agreement between Highlands Water Company and Soderby LLC.
Okay. And so is your position that, as I've seen that represented, and I know the parties are disputing whatever the interpretation is of it, of which certainly I haven't seen, but your position is that that says they have disclaimed any service.
And I think that was, you know,
I'm sorry, is that right, or am I misstating that?
You're saying paragraph 2?
Yeah, let me grab the specific. Sorry, give me a second here.
I just want to make sure I read the exact language.
Yeah, please do. Thank you for, okay, so it's the last part of that first sentence. The first part of that sentence, page 2, paragraph 2. MGMWC plans to provide water to a service area that includes parcels owned by Soderby that Highlands has agreed it cannot claim as part of its existing service area. And so what caused me to address that question was that there's this kind of debate between the parties at this point about what's the limitation of that agreement in terms of exclusivity versus no service at all. And I see here a position of no service at all.
Yeah, and Your Honor, as I read that sentence, it's referencing the settlement agreement obligation, and I think that may have been penned a little bit too broadly. It is they cannot demand, and actually, I think the best thing to do. By the way, we did not include a copy of the settlement agreement because it does have a confidentiality provision. If there were a protective order and Highland was amenable, I wouldn't have any concern submitting a copy of the agreement to the division.
Well, I will let you. Pardon me. Is somebody trying to say something?
Rulon, could you go ahead and mute, please?
I will let you all work that out between yourselves. If it's something that you think is important for the decision-making process generally, recalling, of course, that we're here on the motion or the petition to intervene. But more globally, I'd like you guys to have discussions amongst yourself about that issue as it relates to anybody's respective burden of proof going forward. So I'll leave that to you for now.
Yeah, and certainly that would, I think, be more important in the broader context of the request, service area request itself. I don't think it's necessary at this juncture for the intervention side of things. But I think the key thing is when that statement was written in the petition for intervention, Highlands had presented to the commission, the Morgan County Commission, an assertion that only Highlands could service this project. And in that context, and then looking at the settlement agreement, which prohibits Highlands from claiming itself as the exclusive provider, I think that's where that statement comes from, Your Honor, is we now have an entity going to the commission in the context of a development approval process and essentially causing problems for that development approval on the basis that they're the only one that can provide. When the reality is that specific property is subject to an agreement by Highlands and Soderby, both of which are parties to that settlement agreement, providing that Highland can't make that assertion.
Okay, but Soderby is not a party to this intervention. So let me circle back then, because, I mean, how does this 2021 settlement agreement, and then I'm jumping around a little bit, but you're raising these things that I have in order. I'm going to take them out of order. How does that affect how does that affect Mountain Greens and Villages' asserted interest in this case, that 2021 agreement? Be specific.
Again, Soderby is one of the only two members currently of Mountain Green Mutual Water Company.
Uh-huh.
And it's the primary developer of this project.
Mm-hmm.
And so, you know, whether Soderby should in its own right be an intervener here, I think they felt, and I think justifiably so, that their interests are protected by Mountain Green Mutual.
Well,
I'm sorry,
I am going to interrupt you for a second because I understand that. Just help me understand, though. I'm looking at somebody has to have a significant legal interest, right? And what I know is the only two parties that thus far are asserting a specific significant legal interest is Mountain Green and Village. Soderby's not. Now you say Soderby's interests are protected by these others, but their legal interest doesn't get imputed to the other two to therefore assert as their own. It's still Soderby's. So help me understand how this 2021 settlement agreement, if at all, does to affect the legal interests asserted by Mountain Green and Villages.
Certainly, Your Honor. So I think we see that just a little bit differently.
Okay.
So your statement that Soderby's interests and or rights cannot be imputed to Mountain Green Mutual. I don't think that's the case. As I look at this, Mountain Green Mutual is the entity that Soderby has identified and funded and done things to make sure that it can receive water supply. That's the acting entity to keep its project going with respect to water supply. So in essence, Mountain Green Mutual is an entity owned in substantial part by Soderby, and its mission statement, if you will, is to make sure that that water can be provided to the project. Now, it is true that Mountain Green Mutual is not a party to the settlement agreement. Mountain Green Mutual is not a party to the settlement agreement. That it does not, however, follow that Mountain Green Mutual, for the benefit of its members, cannot use as a factual matter the settlement agreement to support its interests. In other words, it's not asserting a breach of contract or anything of that nature. That would be a right exclusively as Sotheby's. But it is asserting that as the PSC is making its determination with respect to what Highlands service area ought to be, the settlement agreement is an important fact to be considered. And yes, Mountain Green Mutual is the one that is presenting that fact to the decision maker, to the agency. But that does not make the rights any different. In other words, in determining what is the interest of Mountain Green Mutual, the interest of Mountain Green Mutual is to have a clear water supply regime within the land owned by its members. And Highlands' efforts in this proceeding to create to expand its service area around and onto areas where the principals have set up Mountain Green Mutual to supply that water is problematic. It affects their interest at the very least of as this project continues to be developed. One of the first things people do when they are looking to acquire a piece of a project is, who's the water provider?
Yeah.
And right now, if this petition if the request of Highland is granted, there's going to be some significant confusion on that front. Unjustifiable confusion from my perspective, because I don't think the property owners have stated in no uncertain terms that they don't want to receive water service from Highlands.
Okay, well, let's park that for future dialogue if appropriate. But what I do hear, first of all, thank you for your helping me understand better your position on the kind of tracking of whose interests lie where. I appreciate that. But I do hear from you that there's going to be potentially some issues of contractual interpretation. You said there's no breach of contract claim. I get that. But it sounds like there is lurking in here potentially some contract interpretation issue. Would you agree or disagree with me at this point with that statement?
I don't think so. I agree in part and disagree in part, Your Honor. What I would say to that is that on the issue of intervention, I don't think it's necessary to interpret the contract. On the issue of expansion of the service area, I think it could be a helpful fact, but I don't even think that the settlement agreement is the key fact that needs to be determined.
Okay.
So I think that while it may be a beneficial fact that may support a decision, I think that the commission can get to the same place with or without interpreting that agreement. Specifically, because the property owners are looking at this and saying they have selected their water provider and it's not Highlands, the public interest is not served by having this expansion of the service area to include property that won't be served by Highlands.
Okay. And you and I will address this notion with Highlands of expansion versus existing, as you've identified, and I share the need to get that clarified. So I will ask that of them. I want to follow up though on this line about agreements, because there's a 2007 agreement. I think it's referred to in your pleading as the well agreement. Is that right?
That's correct, Your Honor.
Okay, so what effect does the well agreement have on Mountain Green and or Village's significant legal interest in this case or docket?
Your Honor, I don't think there's any effect at all. It is not uncommon for different water providers to have water sources outside their service area. So while Highlands may very well have a well within what we're, I hesitate to call it a service area for Mountain Green Mutual, but where we anticipate Mountain Green Mutual will be the water provider, that that makes no difference in terms of who is actually going to be the water provider. It's simply the well agreement, as I understand it, simply is an agreement providing for an easement and access to a well that I believe is currently owned by Highlands, that is within that green outline that I showed earlier. But that doesn't affect who services the properties around that well.
Okay. And are there water lines that were also installed pursuant to that agreement?
I believe there likely were some water lines approved, installed pursuant to that agreement.
Okay. Okay, so that's my questions on the settlement agreement. Thank you very much. One of the questions, you've answered this, but I guess I want you to be as specific as you can. In your reply, you make the allegation or the assertion that Highlands application could undermine Mountain Green's exemption request, that separate docket. How specifically, and if you're going to have to restate what you said, I apologize, but I didn't get a real clear answer in my head on that notion of undermining. Can you restate it or just start anew?
Certainly. Now, as of yet, Highlands hasn't submitted any comments in the exemption request docket. So, it's possible that that issue doesn't become a significant issue. But there is the risk, the thing that Mountain Green Mutual is really trying to avoid here is to lose its seat at the table with respect to the expansion of this service area on the one hand, and then have Highlands come in on the exemption request on the other hand and make the argument. And I suppose that's one of the hazards of having kind of parallel dockets going on with these related issues. But that said, that's the concern, is that we don't have a seat at the table on this one, which would allow Highlands to then expand its service area. And then at the same time, there's arguments that exemption's not possible because it encroaches into a service area of a certificated public utility, and therefore an exemption's not granted. And all of a sudden, we don't have the ability to protect ourselves in the service area proceeding as it might affect our exemption proceeding.
Just ask you this. So in the initial filing of Highlands, their application, they had attached some exhibits, and two of those exhibits are maps. And I'm going to refer to those here and hereafter as 2A and 3A. My understanding, and I will verify this with Highlands when we get there, my understanding is that 2A, at least visually represented by way of a map, as well as 3A. 2A, in its red outline, represents what I believe Highlands is representing to be its current service area. And then 3A is represented to what I am going to say now. My understanding may change after I hear from them, but is as to where they would like to expand. Given that, Mr. Jensen, do you agree that 2A is Highlands' current existing service area?
As we talk about the boundaries, 2A.
Well, sir, let me interrupt you because why?
Okay.
Let's use their exhibits, because that's the question is, do you think 2A, what I call 2A? And if you need me to orient you to look at that, I'm happy to give you the time you need. And if you want to put it up, you can. I don't know that you need to. But my question to you is 2A, which is attached to the application, one of the attachments, and it is the map representation, and it's in a red outline. Are you with me?
Yes.
Okay. Do you believe that that is Highlands' current existing service area?
No.
Okay.
I think there are portions.
Oh, that's okay. No, I just wanted a yes or a no. That's okay.
Okay.
I mean, that's helpful for me understanding your legal interest. I want to jump back to your reply. You have asserted there, and you also said in your presentation, something about Highlands' inadequacy to serve. And that's my articulation. Specifically, though, in your reply, there's an assertion that is on information and belief that Highlands does not have adequate fire flow capacity to service that area. What is the on information and belief basis?
Your Honor, I think actually that has progressed since we've made our reply filing. Highlands actually presented again at the December 6th Morgan County Commission meeting, and there was assertions in that meeting that I think really put a finer point on the inadequacy of the fire flow. Specifically that their tanks are a significant distance away. Only connector from those tanks to this particular area is a 6-inch line, long distance, low diameter line. The end result is that there's a significant question about the ability of providing fire flow in this particular area. In fact, anecdotally, there was a fire in this area recently, and I don't know this for sure, but I believe that the fire occurred within areas served by Highlands Water Company. But when the fire department came, they went ahead and connected to the hydrant on Cottonwood Mutual's water system to fight the fire, because there was significant concerns about whether they could get enough flow and pressure to supply the water needed to fight the fire. So, okay. Yeah, there's more evidence, and if we really get in, if we're allowed to intervene, I think we can provide testimony to that effect.
Okay. To be announced. Cottonwood Mutual Water Company. They've been mentioned by you here today. I'm sure Highlands will have some mention of them. They have at least commented on the docket, and they're kind of everywhere. What is the petitioner's collective or individual views of what role, if anything, does Cottonwood Mutual Water Company play in this docket as it relates to A, the petitioner's legal interests, and or B, otherwise?
So with respect to the petitioner's legal interests that could be substantially affected, I don't think Cottonwood Mutual is a necessary party. As we sit here today, the only party capable of providing water to this area is Mountain Green Mutual. There may be some efficiencies to be gained by teaming up with Cottonwood Mutual, and that may happen, but that hasn't happened yet. And so as we sit here today, the interest that's at risk by this proceeding is Mountain Green Mutual Water Companies.
Okay. Okay, I guess we'll figure that one out later too. I really appreciate everyone's patience on these kind of pedantic questions, but there's a lot of information here, and a lot of it is presented in a way that has been difficult to follow. And so unfortunately, we have to take it slow, and that's what we're doing. I'm going to continue. So, Council, Highlands has represented that it currently serves the bank on one side of the parcel, and I'm just going to call it kind of the bigger parcel of the 3 parcels in the middle, and then the dentist office on the other side. The representation is that they do serve those 2 entities. Does either one of the petitioners dispute that claim?
No, Your Honor.
Okay. And so that they are serving those locations currently, how does that, if at all, impact Mountain Green's legal interest in this docket?
Yes, Your Honor. Do you mind if I share my screen again? I think it would be helpful to visually see
Please.
how this all plays out.
I'm going to ask the same question about villages. So if you're going to, or about village. So if you're going to use the screen for that purpose, you might want to use it for village too.
Certainly. So this carve out right here is the bank.
Yes.
Okay. This building right here is what they're talking about is the dentist office.
Yes.
So intentionally in mapping this, we've specifically said, yeah, they're not shareholders of our water company. We don't intend to serve them. They're already connected to Highlands, and so that's fine. Now, I think in the response, there's this idea, this concept of, well, we're going to put a grocery store here in the middle. It only makes sense that it ought to be Highlands. Well, first of all, if you look at the scale down here, this is 2,000 feet in the middle. I don't think you can say it affects anyone. There's obviously going to be, and there already is, many different types of service line in the old highway road here. And there's not going to be any effect on any of that. We'll get the blue stakes out there. We'll make sure that the water lines are installed such that they don't interfere with anyone else's water lines or other utility lines. That's all controlled and in place. So I don't think that there's a reasoning to say, hey, you ought to you don't have any interest in having the right water provider or the water provider that you want for this area. Now, of course, then you look at the broader area over here, which is all Soderby property, and then the village property over here. There's really no reason why Highlands should be providing the water there. And that actually is one of the things that is a major concern with the current application or request, I should say, the current request on the service area, because the development agreement for the Soderby project is outlined here in yellow. What Highlands has represented is they have infrastructure to serve what's shown here in blue. And so that's what you referenced as attachment 2A.
Okay.
Is what's outlined there in blue. The red is the area that they might serve in the future. So that's the difference. When the red outline here is the difference between their 2A and their 3A map. And what stands out immediately is that we've got a development agreement on an overall project outlined in yellow, and currently Highlands has asserted their ability to serve the things in blue and a potential ability to serve things in the future, the things in red. And that is a concern for Mountain Green Mutual Water Company, because it is it's the company that's been tasked with making sure that there's water service for everything in yellow and in fact everything in green. So I think that in and of itself, those different boundaries and what they signify identify an interest that petitioners have in ensuring that the right, there's not these piecemeal expansion such that there's a concern that half of their project or 2/3 of their project is without a water provider.
Okay. Thank you for ending with that legal interest. That's helpful. I want to stay with this map. If you wouldn't mind, leave it up, but I'm going to jump ahead to a question. And again, noting that I haven't yet talked with Highlands and specifically about this notion of current existing service area versus proposed expansion. So let's put the proposed expansion on the table for a second. Let's say hypothetically that if Cottonwoods, or sorry, if Highlands were to say, look, we really didn't mean expansion. We just thought we could be there in the future. You know, that might make some sense, but we're not going to do that. We're not ready to do that. And I'm not saying they said that. Do not misunderstand me. This is a complete hypothetical, everybody on this call. But let's say hypothetically they say that. And they say, you know, what do we need to do to clarify our request? Would it clarify our request if we just said, we are going to only use, we only want to determine uncertainty as to what we have identified in our submission as 2A, otherwise shown here on the blue. And that's all we really want. Hypothetically, if that were to happen, what would that change the petitioners, one or both, their legal interest specifically or generally as it relates to this docket, this docket?
I think it would change Village's interest, because Village's property is entirely outside the blue boundary.
Mm-hmm.
That said, I think that there's a lot of I don't want to say regional because it's still a fairly small area, but there's collaboration, there's planning going on, and I think it adds complexity that doesn't need to be there if you have multiple water providers for a single. Again, by way of background, Your Honor, right now, I don't know if you've ever been up to Mountain Green. It's gorgeous. You've probably driven up Trappers Loop to get to Snow Basin or Pine View. There's no village center in Mountain Green. There's a lot of houses and things, and then there's the Sinclair gas station. Well, right now there's in process of putting a highway interchange, and I'm going to get the location incorrect, but I think it comes down through here and ultimately will connect with I-84 here.
Yes.
And this area will ultimately become essentially a town center for the Mountain Green community, which has grown a ton over the last 10, 15, 20 years. And so I wouldn't say that completely gets rid of Village at Trappers Loop's interest, because I think they do have an interest in a robust town center with a water, a reliable water provider, and not to have things muddled up by overlapping service areas that can confuse potential investors or buyers or what have you in that area.
Okay.
I will say, if we're just talking about the blue, yes, then I think Village's interest is less because they're outside of that boundary.
But not Mountain Greens.
Not Mountain Green, because
Okay.
Mountain Green, I think you're exactly, Your Honor. I think when you look at Mountain Green's interest, it is its role is to take care of the interests of its shareholder, is to serve the interests of its shareholders, one of which is Sotheby. And I think Sotheby is the developer of that yellow boundary, and has a big interest in making sure that the water provider for that project, the entire project, is Mountain Green Mutual.
Okay. Thank you. So given that, I've got to assume, but I'll ask, that you saw the response by Highland to Cottonwood's objection. It's actually titled Response to Mike Johansson with Cottonwood Mutual Water Company. Are you familiar with that filing, counsel?
I did read that filing, and I'm trying to remember if I read it. I read it when it came in, but I'm not sure that I read it in connection with preparing for this hearing, so it's not quite as fresh.
Okay. That's okay, and I'm not going to hold you to this, but what I wanted to ask is if you had what your response to it was, because what was provided in that response was what I believe, and we can clarify this with Highlands, is the a representation, again, visually by map, of what the February 25th, 1976 CPCN as filed with the request by Highlands in this docket, where it shows that area is. And that area as mapped, and it looks like there were 3 of the 4 parcels identified in that CPCN that were mapped, showing where that area was. And relative to the map that you just took down, it was right there in the middle. I think you referred to it as Lee's Market, that area. So if you're not familiar with that, I won't ask you any questions about that. But if you are familiar with that, I do have some questions.
I'm looking at I'm looking to pull up the map now.
There's exhibits A through, I think A through D, no, maybe E. And specifically, it's exhibit A is just, again, another copy of that CPCN that was filed with the original request. Then there's an exhibit B that I don't really want to talk about now. It's exhibit C, D, and E, maybe F, maybe even F. I think there's separate, and then at the end is here is all 3 parcels on top of each other.
Just give me a second here. It may be better if we address that on reply.
Okay, that's fine.
But
yeah, we'll do that.
Let me just, is this the map that you're referencing?
Yeah, no, that is not. What I'd like you to do, if you can, and if you can't, that's okay. Because the question is, what in light of this does that do to your legal interest argument? But in the document, the filing that I'm speaking of, there are exhibits C, D, E, and F. C is the mapping of one parcel that corresponds, I believe, to the first entry in that CPCN, and so on and so forth. The 4th, and I think it's exhibit F, then puts all 3 of those parcels together, and it's an image with the parcel lines. So it looks a little bit like what you just put up, but without the yellow or the red and green lines. But you're not familiar with that. I appreciate your candor, so let's just park that for now and move on. Because I think the last question I have for you was in reference to the pending application with the Division of Drinking Water on behalf of Mountain Green. You had mentioned that in your presentation. What's the status of that? And then what, if any, effect does that application and its status have on your claimed substantial legal interest in this case?
So it's still pending before the Division of Drinking Water. Currently, I think the only issue outstanding is source protection for some of the wells. I believe that's the case. So we're still working with some of the neighboring property owners to make sure that we can get to the source protection easements in place. And once those are in place, then I think that's the only obstacle currently holding up approval by Division of Drinking Water.
Okay. And then when issued, hypothetically, if issued, that's just one more part of the overall plan of which you're saying is the thrust of your substantial legal interest.
Correct.
Okay. Okay, I think I don't think for now, that's all I have for Mr. Jensen. Thank you. Have a drink of water.
Thank you, Your Honor.
I'm going to move over to Highlands now. And Highlands, what I'm going to do is invite you to give the presentation that you were prepared otherwise to give, if you'd like. You're also welcome to make statements or opine on any of the questions I asked Mr. Jensen and his responses. However you'd like to proceed, the floor is yours. So please go ahead.
Okay, are we unmuted? Can you hear us?
Yes, you
Okay.
are.
I felt like going into this today that one of the important things to clear up is the matter of the 2021 settlement agreement, because although I think Mr. Jensen said today that that may have been overstated or something, in fact, last night as I was going over things, I meant to count how many times that settlement agreement is referenced between the petition to intervene, the opposition to our service area, and the application for the new water company to have exemption. So that seems to be a very big part of this proceeding. And I would like to read from the settlement agreement, which it does have a confidentiality clause, and I don't know how they could share what they did, but it's been shared, so I feel like I can read the exact.
Well, let me, I'm sorry, Ms. Smith, let me interrupt you for a second on that point. Okay, so this is a public proceeding. We have to pretend that we're out in the courthouse and anybody can walk in and out whenever they'd like. So while you know at least who at the beginning had identified themselves as being here and from where they are coming from, that was then. And so to the extent you're going to make a decision to disclose something that you've admitted is confidential, you're welcome to do it, but you're welcome to do it at your own risk. I don't know what that would be. But I guess the bigger question would be, is it important on the issue of opposing what has been represented as a significant legal interest in this docket? And if so, then you're welcome to do whatever it is you'd like to do. I just wanted to caution you, okay?
Thank you. Thank you. I'm only going to read what has already been shared in the docket information by Mountain Green Mutual Water Company's attorneys.
Okay.
So nothing, well, just a few more words that they didn't include. I'm just going to read that paragraph, and it's already in the docket material. So it's already been publicly, if there's a breach, it's on their part. So I would just like to read that so that we can see exactly what it says. And it's, like I said, it's in the material already. So it says, to the extent the well agreement could be construed to require Johnson to use Highlands as the exclusive water provider for the Johnson property described in the well agreement, Highlands expressly relinquishes any claim that it is the exclusive provider of water for the Johnson property described in the well agreement. So I would just like to assert that that does not mean we cannot provide water, which is the implication that the opposition has presented, is that makes it impossible for us to serve that property because of that statement. I believe that the interpretation of that statement is that we cannot claim to be the exclusive provider, and we don't claim to be the exclusive provider. And I'll address the comment that Bart made about that in a moment, but it does not imply that we are excluded from being a provider. It just says we are not the exclusive provider. So I'd like to just put that out there. Now, Bart did make a comment in a commission meeting, just kind of off the cuff, and we had just learned that day that really that we might have a responsibility to serve that area because it is in our service area. I don't think in fact, Bart can speak for himself if he'd like, but I don't think his intention was to say that we were we were claiming that we would not allow anyone else to serve that area. Do you want to make any statement on what you
Ms.
said?
Smith, I'll tell you that I would not like to hear from anybody other than one person on behalf of Highland, and you've taken the podium, and I'm going to have you keep it.
Okay.
Unless, of course, there's something extraordinarily pressing. Otherwise, I'd just like one spokesperson.
Okay, that's fine. Thank you.
Thank you.
Anyway, I believe that was, like I said, that was a statement. I didn't go back and listen to the meeting to see if it's exactly the way was said, the way they said. My remembrance of that, my recollection of that is just that we said we may need to be the provider because it's in our service area. At that meeting, it was not clear at all who would be the water provider for the Lee's Marketplace project. It was very up in the air. And so we basically have just said, we are able to provide water to that project. We have not said that we exclude anyone else from providing water. So that's what I wanted to say on that statement. I think it's not proper to ask the Public Service Commission to interpret that single paragraph from the document in a court case that was very complex. So as far as that being the basis for decisions made about whether or not Highlands can serve that property, I think that needs to be excluded because it is an interpretation. Their interpretation is different than ours, and I really believe in my interpretation. Anyway, okay, Dwayne and his partners in Lee's Marketplace have approached us multiple times to serve Dwayne's property. In fact, Mr. Johnson, yes, I should say Mr. Johnson and his partners in Lee's Marketplace. During the 2020 lawsuit that the settlement was in 2021, Dwayne Johnson came into the office and demanded a will serve letter for an apartment complex on this property. And
Ms. Smith, let me interrupt you on that. Is that Mr. Johnson on his own behalf, or is that Mr. Johnson on behalf of a specific corporate entity?
let me look at it.
And if you don't understand the distinction, please, I'm happy to try to explain the distinction.
It says Sotheby LLC.
Okay.
Requests Highlands Water Company to issue a will serve. So yeah, I don't understand all the difference between the entities. So
okay.
Say that. Again, after the lawsuit, Dwayne has approached us about whether we would serve his property. So I'm just stating these things because that's an issue that was raised, saying we shouldn't even have asked because we should have known that Mountain Green Mutual Water Company was going to serve the project. And that has not been clear to me because we have been approached. And so, again, for us to, so as we sent in our request to update our service area, we did not know it was going to create all these issues. We just put the areas, we just outlined the areas that we currently serve, and that area that we had the paperwork that showed that it had been certified by the Public Service Commission into our service area in 1976, and that's the map that you referred to, and parcels 1, 2, and 3. The fourth parcel, there's some inaccuracies in the description that make it hard to plot that one. I may be able to get that plotted, but I didn't at this time. I just showed parcels 1, 2, and 3. I'm not sure what parcel 4 included, but that does show that is already in our service area, and that's why it was included, not in an attempt to exclude anyone, or it's just that's what our service area is. So I've got notes that I've taken, but
That's take your time. Take your time.
thank you. Anyway, just don't feel like it's improper for us to ask to have our service area updated with simply those areas. The map that you referred to with the blue outline showing our future service area boundary, that's not what we're trying to have recorded or certified. It just might, it was just maybe that was helpful to show areas that we could possibly serve in the area. We're not claiming to serve those areas in any way. It's just areas that we could possibly serve. The thing that we're asking to have updated and certified now is simply the areas we currently serve and that are currently certified in our service area. And that is not an expansion. I don't consider that. It keeps being referred to as an expansion, and within the community has been made to sound like we're trying to grab area that is not ours. I don't see.
Let me interrupt you for a second, Ms. Smith. I just want to be clear on that. I think that's helpful to know. So let me just restate what I think you just said, and please say yes or no. Really what your application the request seeks to do at this point is memorialize what is represented in what I earlier called Exhibit 2A, which is the graphic or map representation with the red outline. And that representation is, as you represent today and in your request, what you believe is Highlands' current existing service area. Is that correct?
Yes.
Okay.
Very
that was so compound. You did a great job answering it.
Thank you. Okay. Another question I have today is involved, and anyway, Cottonwood Mutual Water Company has given a will serve letter to that property where Lee's Market, and I wanted to point out that the area under my desk, the area that Mr. Jensen pointed out is a large area. It's true that's relative to whatever you want to compare it to, but I would like to point out that that is a 6-lot subdivision that fills the entire area, and that's what the request for a will serve letter is for, the 6-lot subdivision encompassing the entire area, not just the Lee's Market grocery store. And so that's what Cottonwood Mutual has given a will serve letter to serve, that 6-lot subdivision in that area. So it's that's a conflict between what and the entity, like, this is hard because the entities are interconnected. The Cottonwood Mutual Water Company and the Mountain Green Mutual Water Company, there's connections especially between the infrastructure that they're claiming to be able to serve the project with. It's the same tank and the same wells. And so it just is so confusing about who is going to serve that. And Mr. Jensen's made it very clear in his presentation that Mountain Green Mutual will serve that, and yet Cottonwood was asked for and given a will serve letter to serve it. So that's, I would like to have that clarified. And then I'd like to speak to the information and belief that Highlands Water Company lacks storage and distribution lines, fire flow. I would like to know where that information and belief comes from, because none of these entities have spoken to us or looked into, I don't know where that comes from. But I will say that we do have source, storage, and capacity to serve. We currently serve, as was mentioned before, the bank and the dentist office. We serve the subdivision on the other side of the road. We serve those currently. They're wrong in saying that the only thing that connects our tanks is a 6-inch line. They do not understand our system. It is not connected with a 6-inch line. We have 14 and 16-inch lines that connect our tanks with our system, not a 6-inch line. And we have fire flow tests that show that our fire flow is adequate. The fire chief it meets the requirement. And the fire chief just recently restated to us that he has flowed fire hydrants all over our system and they have all been adequate. So I think that statement is, and they've made it, and they made it in commission meetings, and a commissioner that is part of this firm that Mr. Jensen belongs to, questioned us about fire flow. I explained it, and anyway, I don't know why that is still being said, because it is not true. And again, they have not come and talked to us or seen our system, so I don't know where their information and belief comes from, but it is inaccurate. Cottonwood or Mountain Green Mutual Water Company knowingly included in their service area, which is, I wish I had the ability to put things up on the screen, but the red, they submitted a map with a red area that they said would be their service area, and that they know that in that part of that service area include customers that are currently our customers, and I will show that the best I can. Okay, so we have customers in this area right here that we
Hold on one second, Ms. Smith. And Mr. Jensen, if you're uncomfortable agreeing with me about this, that's fine. That looks like one of the exhibits that was submitted in connection with your with Mountain Green's exemption request, which was attached as an exhibit to your intervention petition. And the specific exhibit, I think, is going to be at the end as attachment to the explanatory of 4. Is that ringing a bell to you, Ms. Smith? Don't put that away yet. I didn't want to interrupt you that way. We've got a court reporter who's trying to record what's being done, and it's hard to do things that aren't otherwise audible. So we need to explain it very pedantically. So hold that back up again, please, all the way to the screen.
Okay.
And don't say anything. Let me just let Mr. Jensen take a look at it. I guess it does look a little bit different from, no, it doesn't. It looks exactly like what I have in my hand. which by way of orientation, Mr. Jensen, in that application for exemption, the explanation with an asterisk in the bottom of that map is that Highland Water Company also provides water service in this vicinity. That's the text at the bottom of that exhibit.
Yeah, I'm just looking to see exactly. I think it may be something that was submitted to the Division of Drinking Water, not.
No, this
So
is from the Public Service Commission docket.
Right, but as an attachment of the application to the Division of Drinking Water, I think is where that map. I think that map has been refined based on what we've based on this proceeding, and so the map that we attached to our filings, the one that I've been sharing on the screen, is the more accurate map of where we anticipate servicing. That said, we only can service our shareholders, so it's not a hard and fast boundary. It's about where our shareholders live.
Yeah, and that's a good distinction that everybody should not forget for purposes of proceeding going forward today. Okay, so I am going to say that we can't get agreement on exactly what it is Ms. Smith is referring to for the record. But please, Ms. Smith, continue as best you can with what you have. Okay,
I will say I'm looking at the map that Mr. Jensen put up on the screen before, and the red area right here looks to me to be identical to the green area on that map, which is identified as Mountain Green Mutual Water Company service area. So that being said, do you mind putting that map back up? Maybe I could. It would be hard for me to point out.
I guess I've lost your point. What is it that, and this is maybe me not having enough coffee. What do you need these maps to support by way of your argument?
I'm just saying that we have current customers in these areas. Let's see, this parcel right here, we serve the home in that parcel. We serve homes in this parcel, this part right here. So I'm saying that within the service area that they are claiming to serve, the area that they're claiming to serve, we currently serve customers there.
Okay.
That, to me, is a problem.
Okay. And I think I think you've made that point without necessarily needing to refer to the map. So thank you.
Okay, thank you. And again, this map that they show, it does show Cottonwood Mutual in the blue. It does not, the only, as you pointed out, the only reference that it has to Highlands, it does not show our service area. And I believe it should have shown our service area, but it just says that because of the settlement agreement, again, seems to be the key point that they make, that the settlement agreement alters our original boundary and we can't serve it because of that. So I just think that our service area should have been included in that map.
Okay.
We have been concerned about having 2 or 3 water companies. As stated, we already serve on both sides of that property. On 3 sides of the property, we have water lines that go around 3 sides of the property in question, and in that 6-lot subdivision. And so to have 3 water companies, Highlands, Cottonwood, and Mountain Green Mutual Water Company, all having pipes in the same area, is a concern to us. Okay, let's see. And they have acted very aggressively toward us in this docket, and so that is a concern because we will be neighbors and be serving the same area or close to the same area. I would like to go back to Mr. Jensen let out with saying that there were two reasons that you could become an intervener, and I don't know if I can find that quickly enough. He said number one referred to legal interests, and number two referred to something about justice. And he said that because I didn't mention that, I had conceded that point. And I don't even know exactly what that point means. So I don't know whether I conceded that or not. But by not, another assertion that they made is that because in the map with the red outline, our map with the red outline showing the service area that we would like to have updated.
And that was referred to earlier as your request attachment 2A.
Yes.
Okay.
2A,
For the
yes.
Okay.
2A, that because we included that in that map and we didn't include the other portions in that map of Mr. Johnson's property, that implied that we were not able to serve that. That is incorrect. The only reason the other part of his property was not included is because we don't currently serve it. It is not currently part of our service area, and that's all that we were trying to establish is our current service area. So I worry when they make implications like that. Let's see. I'm just looking over my notes. Okay. As a water district was mentioned, that there have been discussions about a water district. Just a matter of point, we've not been involved in those discussions nor invited to those discussions. So I'm not very familiar with that. I think those are my main points. I don't know if this is my last chance to speak, if I get a chance after Mr. Jensen speaks again, but all that I want, my bottom line is I would like my current service area to be updated and certified and acknowledged, and about serving that area that is in question. We will certainly talk about that. In fact, that would have been a nice approach had they just, instead of creating all of this confusion, to just come to us and say, because we don't have to serve that area. We have plenty of customers. That's not contingent on our success as a company to serve this area. We just were trying to certify our service area. And if they would like to come to us and talk to us about serving that area, we would be willing to talk about that. We're not we're not saying we are that we have to serve that we are the only ones that can serve it. We're willing to look at other interests, but I would just like our service area to be recognized and move forward from there. And I am concerned about the disparaging comments that they have made about our ability to serve. And anyway, that's where I am at. I would just like to have our area certified, and if they want to talk to us about other issues, then that's fine. And I think the issues between Cottonwood and Mountain Green Mutual can be worked out between them. But the map, I did want to say one more thing. The map that you referred to and Mr. Jensen brought up, let me pull up that map as well. This is the map that he brought up, and it actually is the map that shows the parcel where some of our service areas in connection with that area, but that does show the 3 parcels that that since 1976 have been included in our service area.
And Ms. Smith, could you be more specific and identify for the benefit of the court reporter and everybody else what it is that you're referring to by way of a map? That is, where did it come from? What was it filed with? Where can we find it if we want to look at it?
Yes. Okay. Let me. I believe that was filed. I believe that is with the Cottonwood. My response to Cottonwood Mutual Water Company's opposition.
Okay, so that testimony just told us that it may or may not be. It didn't tell me it is, and it also didn't tell us where in that filing, because there's multiple maps in that filing.
Okay, I'm sorry.
That's okay. No, that's okay. Just take your time. We just want people to understand later when we're not all sitting here,
right,
what it is we're talking about.
Yes, right. Let me see if I can pull that up and so that if I can pull this up and tell you and clarify that better.
Okay.
If I understand your point. Okay.
This is what I'm going to propose. I'm going to propose we take a short break. We've been going at this for a while. So I'd like to take a break. I'm going to say 6 minutes because my computer says 11:44. Let's circle back at 11:50. And at that time, Ms. Smith, maybe you'll be able to orient us better on your last point. And then I would like to begin asking you a few questions so we can keep moving this along, okay?
Thank you.
Okay,
Yeah.
We'll come back in 6 minutes.
Thank you.
2-010-01, oral arguments on the petition for intervention by Mountain Green Mutual Water Company and Village at Trappers Loop LLC. I anticipated this hearing would take a while. It's taken a little longer than I anticipated, so thanks everyone for your patience. I hope that break was refreshing. I'd like to pick it back up where we left off, which was Ms. Smith was going to try to better clarify and articulate where this exhibit she was talking about coming from.
I just found the map, not the map that I had made the circles on, but I did find the map. It's Exhibit F, I think is sufficient, that shows the parcels.
Exhibit F to what?
It's Exhibit F to my response to Cottonwood Mutual Water Company's protest.
Okay, thank you.
So I think that's sufficient. I did remember one other point that I wanted to make, that Mr. Jensen brought up the recent fire, and that it's confusing to me because there was a fire. It was in Cottonwood Mutual Water Company's area, and it was their fire hydrant that was used. It had nothing to do with our area. So I don't know what he meant by that. They did not hook up to a Highland Water Company hydrant and then have to hook up to a Cottonwood. That fire was all within Cottonwood Mutual Water Company. So I don't understand what he was talking about. There was nothing to do with us and that fire.
Okay. Anything else, Ms. Smith, before I ask some questions of you?
No, go ahead.
Okay. No, thank you. One thing I want to begin with, though, is Ms. Smith at the end was talking a lot about there's been no discussions amongst the parties. That's up to you all. I will say, as an outside observer, there's a lot of moving parts here. This is already semi-common. Encourage parties to at least have dialogue so that people aren't guessing incorrectly what the other party may or may not be doing. I've always found that I like to be at least know if my guess is wrong or right. But in any event, we is that you think are appropriate. Certainly not ordering you or mandating you, but because it was broached, I thought I would chime in that it doesn't ever seem like a bad idea to me. But with that being said, I want to talk with Ms. Smith about Highlands' initial request. One of the issues here, so the big issue here is Mountain Green and Village meeting its burden to show why it should be at this party. Well, that's contingent a little bit on some of the things that you have filed, or that have been filed, pardon me, on behalf of Highlands. And so I want to start with the actual request filing. And I'm going to just run through it because I don't know if some of these things are intentional or not. And if they are, that's fine. If they're not, we want to get it fixed. So there is a reference immediately in the cover letter, which we'll characterize that as the request. That's a cover letter dated September 20th, 2023. And it makes reference to a CPCN 1520. It's in the ray line. So the second, right below the word RE. Where is that certificate of convenience and necessity? Do you have a copy of that? Oh, that's okay. Just if that's and then it continues to say that the last sentence of the first full paragraph, it says, quote, service area expansions were granted to Highlands in the following proceedings, colon. Do you see that?
Okay, yes.
Okay, and then there's nothing that follows that. What proceedings, the use of a colon tells me as a reader that you're about to list a bunch of things that precede the colon, which is the preceding numbers. They're not listed here, so my question is, am I missing something? Was that unintentional?
That was unintentional. We do have case numbers here that show that areas had been added to our service area over the years.
Okay, I'd like you to read into the record right now those docket numbers, because otherwise they would have or should have been in your initial filing.
Okay, there is, let's see, case number 5572. And that was amended the following year, case number 5572-1. And then the 76 one that has been, I can give you that case number.
The 76 one is attached as an exhibit, correct?
Yes,
Okay, so that's 5722 and sub 4.
yes,
Okay.
yeah.
Are there any other cases or dockets which you meant to include after that colon in this filing?
Your Honor, just if I could, for the 1976 filing.
Oh. Is that?
Well, Mr. Jensen, good catch. That was one inconsistency I didn't pick up on.
Okay.
Just wanted the record to be clear.
Well, I think it's good because this is helpful, because these are supposed to establish what looks like attachment 2A.
Yeah, that's a mistake, sorry.
Explain specifically what the mistake is. Is it that attachment
attachment 1 CCNN. Oh, wait. Well, it was CCNN number. That 1520 is our CCN. It should have said case number 5572, sub 2 and sub 4.
Okay. And it matters that I have a couple others. The next full paragraph, and I think this is important. I think it's been cleared up a little bit, but I'm not quite sure how finally it's been cleared up. But it reads, we are requesting that the service area descriptions and maps be updated to reflect Highlands' current infrastructure, service area and immediate planned extension of infrastructure and service areas. So my question is, and then you say in your opposition to the petition for intervention, your inline comments, because the way you responded to that opposition was you provided what we call inline comments, red line,
Right.
whatever, on the document that was submitted. You say that Highlands is not requested to expand its service area. And so I'm trying to reconcile, I mean, I know what you said today, but when I read your request, I think Mr. Jensen was also probably under the same understanding that it looks like you want to do two things. Where you think your service area is, and then two, you also want you want an okay to do an immediate plan extension, which sounds to me like expansion. So what are we misunderstanding based on your language in the actual request?
Okay, of our project service area. Let's see. We honestly we put our current service area in there, and it was suggested by the Public Service Commission that we add the projected service area. And I honestly, I just, like, I'm not an attorney, and I should have been. I just can say that I did not expect it to be this big a deal.
Okay.
And I wasn't as careful as I should have been, or had an attorney write this. It just is I understand what you're saying, and I agree. It's confusing. I would like to go by what I said today, that I don't care about the expansion. That's just what's possible.
Okay, so let me stop you for a sec. First of all, have you engaged legal counsel at all on this anyway?
A few questions to our attorneys, all.
Okay, that's helpful to know, because what I don't know is how we're going to correct this, and I'm not going to say anything about it now, but at the end of the day, your cover letter serves as a request. And basically it's your way of talking to us, saying, this is what we're requesting of you. Okay, and then Mr. Jensen and his clients get this, and they say, okay, this is what they are requesting. And the way it's written, and my interpretation of it, I think is consistent with what I believe Mr. Jensen's client's interpretation of it was that you want two things. One is, let's just get our current existing area established. And then from that, let's let you know where it is we are going to go. So we want you to let us go when we go there. And that was my interpretation. And what I'm hearing you say now is, no, it's really just the first component. We just really want clear where it is that we think we are. And we don't care about the second part. Okay. Because this is a pleading environment, we may need to have you amend your submission on that point so that anybody not at part of this call, for example, Cottonwood, might look at this and have a different view of what's at stake. But I'm going to park that from now. Now that I have your understanding generally, that's something I'll need to decide on how we're going to go procedurally.
Can I ask, is the Mike that is listed here, is that Mike Johansson from Cottonwood?
I don't know. Mike, would you identify yourself?
Yes, I'm Mike Johansson.
Okay.
Cottonwood.
Okay, well, whether or not Mr. Johansson is here, he's not a party. So he may decide that he wants to try to become a party or something to that effect. Mr. Johansson, I'm glad you're with us today. Okay, I've got to continue again because I can't tell you enough how important this submission is that you've provided, because it sets the stage for everything that we've been doing since you've provided it. So I want to make sure it's very clear. Okay, so working through it, we then have 3 bullet points at the end of that cover letter. And the first bullet point references an attachment 1. And that is what is titled, in essence, case number 5572 sub 2 and sub 4. It has an issuance date of February 25th, 1976. And it makes reference in paragraph 1 under findings of fact to different case numbers. Do you see that?
Yes.
As you read off the cases that you thought would follow the colon, as we earlier discussed in your letter, you seem to list all of these except for case number 6328. Do you see that in that paragraph 1?
Yes.
Okay. What, is that another case where?
Well, I believe that was a rate increase case, so because it wasn't a service area case, I didn't think it applied.
Okay. Okay, then staying on attachment 1, I will note that pages 4 and 5 are missing from what was filed. Was that intentional or was that accidental?
I 4 and 5.
And when I say that, what I'm looking at myself is that which I have gotten off of the docket, which reflects that which was submitted by the filer, you or your
Right.
company. And it is missing pages 4 and 5.
I until you said that, I did not look at the page numbers. That's all that's in my. I can look through our files and see if there is a document that shows 4 and 5. I'm wondering if, because I know that missing from this are the maps, that it refers to some maps, and I have not found the maps in any of the old papers that we have. And I wonder if that was page 4 and 5, but I didn't look at those page numbers to see that those were missing. So.
Okay. Well, I think it would be beneficial for us to have a complete copy of that which you are relying on, at least partially, in trying to establish that which you represent is in Exhibit 2A to establish your existing area. Because again, it's that which has provoked Mountain Green Villages to have an interest to be here today in front of us.
Okay.
So the accuracy of that is important.
Yeah.
So,
I will try to find that. I will say that in looking in the that I've done previously, this is all that I found, but I'll try to find that with page 4 and 5 included.
okay. And you anticipated another question I was going to have, which is the reference to a map, which of course I don't see a map with
Right.
that filing. And your testimony was that you too don't know where that map is.
I have not seen it with maps, and that's why I hired someone to draw a map from the legal descriptions given.
Okay.
Because that was all that we had.
Okay. And then on that point, when you say draw maps, I want to focus on, I'm jumping ahead here. I want to focus on what I've characterized as Exhibit 2A. And that's the visual representation or a map representation with the red borders.
Mm-hmm.
Are we all on the same page about where I am?
Yes.
Okay. And it seems to me that map purports to represent graphically that which is in attachment 2, which is actually the legal description, non-graphic legal description of the locations. Is that accurate?
Yes.
Okay. And so you just said you hired somebody to make a map. Did you hire somebody to make this 2A and 2 map?
Yes. Our engineer company made these 2 maps. The other
No, let's just stay on 2 and 2A.
Okay, yes,
Okay.
those were done by our engineering company.
Okay, and they did that for purposes of this docket.
Yes.
And from where did they get the information to plot these coordinates?
From us.
And what did you give them?
Well, I don't know, what did we give them? We gave them, they have records of the areas that we serve. So, they have those records, and then we gave them this, page that shows the other. I didn't, there are other, like those other case numbers that we talk about that have legal
Yes.
descriptions, but I didn't give those to them because that is already included in where we serve. Just this one was not,
Ma'am, excuse me. When you say this one, what is this one? What are you talking about? 2A?
well, okay, I'm sorry. Okay,
That's okay. And remember, 2A is what you attached to your initial filing, and it's got the red outline of the territory.
yes. So 2A, for 2A, our engineers have the information about our current customers. So they use that. And yeah, probably use county plat maps to get those legal descriptions. They did have a copy of the exhibit that we've been talking about. I was just saying I did not give them copies of the other case numbers because those areas are included in the customer list that we already have, the customer areas that we already have.
Okay.
Does that make sense?
Yeah, it does make sense. And for purposes of where we are, again, what I'm trying to test is the legal interest that these folks claim they have. And if there is a problem with the accuracy of what I'll refer to as what I have referred to as Exhibit 2A to your filing, you heard Mr. Jensen. I asked him a question if he thought Exhibit 2A was an accurate representation of Highlands' current existing, service area, and the answer was no. That he does not, or his client does not believe that. And so ultimately in the case, depending on where it goes, that needs to be established that in fact is accurate.
Okay.
That being said, that's why I wondered, where did this map come from? Because it had to come from somewhere, and the coordinates, as you've just explained, could have come from a number of different sources, one of which would likely be authorization from the commission over the years to expand your Highlands service area boundaries.
Right.
Okay. So in any event, what we know is that this map has not been conceded to by the petitioners as accurate, and therefore the accuracy of this map doesn't seem to play into their legal to any concern about their legal interest, because you say it's this, they say it's not, they say they're going to be in this area, so we can move off of this particular topic. I did want to know, there's a reference in this attachment 1 to a place called Wagon Wheel Trailer Court. And the reason I'm curious about this is because I know as a Utahn that sometimes places get names, and that lives for generations, those particular names. And I wondered if institutionally you have any understanding of where the Wagon Wheel Trailer Court is, if it still exists or was.
Yes. The wagon wheel, I don't know exactly where you're talking about that it refers to that, but the wagon wheel property is where the Lee's Market area is. That used to be the wagon wheel property.
Okay.
And yeah, it's no longer there, obviously.
Okay, but its name lives on, you see. I'm not the only one who knows
Right.
that.
Right.
Okay. Moving on. I know you're not a lawyer, and I know you're not I don't know this, I assume you're not a surveyor, but I want to know what your testimony would be to this question. What specific city or town is Highlands service area in, as represented by Exhibit 2A?
Unincorporated Morgan County. There's no city. Morgan.
And there's no township?
No.
Okay. Would your answer be the same to that question if I were to ask you it with regard to Exhibit 3A, which is the expansion or extension item?
Yes, that's also in unincorporated Morgan County.
Thank you. So another housekeeping piece, in Highlands' response to the petition to intervene, and that was the one where you put inline comments on the actual document that was submitted by the petitioners. You attached an exhibit, and it's titled on our docket as Exhibit F, HWC, all parcels marked.
Yes.
And what I want to ask you is, with respect to that exhibit, I have no understanding of the two green circular lines, and then the red line in the middle. And I'll give everybody a second if they want to grab that to refer to it while we're talking about it.
Okay.
So, Mr. Jensen, do you see what I'm talking about?
If you can give me just another
That's fine.
30 seconds, I'll have it.
No, that's fine. I want you to have it as well.
This is the map that he put up previously.
No, this is not. This is a map that has lines that are on that were not, I don't recall seeing earlier.
Okay.
I have it now.
Okay, thank you. So, Ms. Smith, my specific questions are this. On that map, there are two kind of oblong or circular green lines, one on the left side of the document and one on the right side of the document. Do you see those lines?
Yes.
What's the intent of those lines? I don't see a reference to them anywhere.
Well, let me see. I think, did I put in the explanation?
I couldn't find one. I'm sorry. And if you can point it out to me in the inline comments, that would be great, but I couldn't orient myself between the two.
Just the green on the bigger green circle is just current customers.
Okay.
And the green on the other side is also a current customer.
Okay.
And they just were areas that were included in their service area that we actually have customers. Actually.
Okay, and then the red line, there's a red circle in the middle. It's
right. And it says rough area of Lee's Market. So
yeah.
it's just marking that.
Oh, so the red line corresponds to the rough area of Lee's Market.
Yes.
Okay, thank you. All right, hitting the home stretch here. Is Highlands aware, we've been talking about this a little bit with Mr. Jensen, but is Highlands aware of Mountain Green's pending application for exemption?
Yes.
Okay. Is Highlands planning on doing anything in the face of that application?
I have not decided yet.
Okay, that's okay. You don't need to, in case you talk to a lawyer or anything like that, you don't need to worry about telling me why.
Okay.
Okay. The last question I'll ask you is the 2007 agreement between Sotheby and Highlands. That seems to not be, I mean, that's the well agreement. And you know, it's addressed, we've talked about this a little bit, but I'm not real clear on the distinction between the two being the April 2021 agreement and the 2007 agreement. There's been discussion about the 2021 agreement. What, if any, effect does the 2007 agreement have from Highlands' perspective on this docket?
The 2007 well agreement was, it included, I don't know if I have it. Let me see if it's in this file right here. It was an agreement between Dwayne Johnson or Sotheby. I don't know which entity. It may have been listed as Sotheby. About our well was drilled on his property, and the original agreement stated that he would receive 50% of the water, half of the water from that well, and we would have an easement to the well and would serve his property from that well.
Okay, you used the phrase original agreement. What is that? Is that the 2007 agreement?
Yes, I'm sorry.
Okay, because I'm trying to understand the distinction between these two, and I've kind of been operating on an assumption that the 2021 agreement folded in some issues relative to the 2007 agreement, but I don't know that. I don't know that.
Right. So he sued Highlands Water Company, and the 2021 agreement was the settlement of that lawsuit concerning the well agreement.
Which I keep referring to it as the 2007 agreement, but that's one and the same, correct?
Yes.
Okay. Sorry, Brooke, I'm confusing you.
No, you're good.
Okay, last question for you is, what, if any, role do you see Cottonwood Mutual Water Company playing in this whole situation in any way, shape, or form? And this is informed. I know you may not have facts. I just need to know what your view is about Cottonwood's role or non-role in this whole thing.
I think that I guess it's confusing to me as well, because with the two water companies, I believe that originally Rulon Johnson Gardner, I'm sorry, I'm nervous. Rulon Gardner was the owner of Cottonwood Mutual Water Company. I don't know exactly what his role is now. He is a principal in Mountain Green Mutual Water Company. He's has been understood and established. I think that if these are just my opinions, I'm not informed on on them at all, but just observations and things that I understand or think I understand. I believe that if Mountain Green Mutual Water Company doesn't get approval soon enough, they want to use Cottonwood Mutual Water Company to serve Lee's Market. Lee's Market has already started construction by getting exemptions from the county, and they really are at a point they really need to have a water company with a will serve, with a valid will serve. I think that my understanding understanding is that Mountain Green Mutual Water Company has given a will serve, but because they're not an approved water company, it has not been accepted by the county. My understanding is that recently Cottonwood Mutual Water Company gave a will serve to serve Lee's Market and the surrounding lots. And so, and yet in this proceeding, they've said that definitely it's going to be Mountain Green Mutual. So I don't know if they're just using Cottonwood to get a will serve so that they can move on, and then they will then become the water company. I don't know. And as far as relating to my service area, I know that Cottonwood has a map that they, and have had maps. I've seen maps, different ones over the years, where they have said this is our service area. But I also know that without customers there, I don't know. Anyone can draw a circle and say this is draw a line and say this is our service area. So I don't know if they end up being the water provider for Lee's Market and it is in our service area, then again we can work with them. Let me think if there's anything else that I think is relevant. Just I know Cottonwood did put a line in last year with a fire hydrant into that, a little bit into that area. As far as their role in protesting our service area, I did have a question, because of the statements made that they will take that Mountain Green Mutual Water Company will take our customers when they become a water company, will take the customers that we now serve in that area. And I know that Mike Johansson in his Cottonwood's protest was concerned about the property, reference the property where the Rome subdivision is across the road. I don't know if they are planning to try to take those customers from us as well. I don't know.
Okay.
That it's a concern, but that's all that I know.
Okay. Well, I don't have anything else. Thank you very much. You did a great job. I really appreciate your thoughtfulness. And what I would like to do now is turn it back over to Mr. Jensen. And Mr. Jensen, I know we've gone far afield. I'm really trying to keep it on the legal interest. So if you please feel free to reply however you'd like. But if you'd like to highlight specifically the legal interests that are significantly at issue with respect to both petitioners along the way, that would be great as a recap. So the floor is yours. Thank you.
Thank you, Your Honor. Very quickly, I thought it would be helpful. One line of questioning that you had, Your Honor, related to existing service area versus expansion area. And so if I may just share screen here. So this is what we've been calling attachment 2A to the Highlands request. And what I want to point out is, as you look at this map, and again, focusing on this area south of Old Highway Road, which is the area, that we're concerned about is Mountain Green Mutual. Then looking at the response, Highlands response to the Cottonwood Mutual Water Company comment on their request for service area change. This is Exhibit F. You can see what they've mapped out in terms of that docket number 55-72 sub 2 sub 4. They had someone map that. I believe that's what Ms. Smith said. We actually also attempted to map those descriptions, and they're a little bit of a mess. We didn't get something quite as clean as this, but just for the sake of discussing, where we're at here, that if this is what was added in the 1976 PSC docket, our concern is, and again, we'll refer to the map that we had prepared. This is Soderby property that is within what they've identified as the existing service boundary, and yet is not identified as part of that 1976 edition. We're not aware of any, any mapping that, or any PSC proceeding that added this area. And so that's when the question was asked, do we agree that the map 2A reflects the existing approved service area? We've seen nothing to suggest that that is accurate. And then finally, we do think that it's relevant with respect to the settlement agreement that there is an agreement, the 2021 settlement agreement, that all of the Johnson property, which includes everything here in yellow, is Highlands cannot put itself out as the exclusive provider. What does that mean? And I think that is an issue on the merits, for which I think it's very important that Mountain Green Mutual and Village be parties to present their side of things. And that is, I think it means at the very least that Highlands cannot assert itself as the service provider for this area without Soderby's consent. And, that is, I don't think there's any dispute that Soderby has indicated it does not want Highlands as the provider. All the requests following the settlement agreement in 2021, there have been some requests, but they're from the Lee's Market team, not the landowner. And so, again, as we look at what is the issue before the commission today,
Yes.
it's whether intervention is appropriate. And the only issue on that front is whether petitioners, meaning Mountain Green Mutual and Village, their legal interests may be substantially affected by the proceeding. We've met that burden. There is enough before the commission to indicate that there are interests that could be harmed by proceeding along, whether you want to call it expanding the service area or whatnot, setting the boundaries where they're proposing to put them, even in the limited boundary of what they've called the existing area, would impact Mountain Green Mutual in terms of providing ambiguity on who the water service provider is, in terms of the assertions, whether or not they decide to participate in the exemption application, and assert that we can't have expand or create our water system in this area. All of those are interests that are hugely important, to the tune of a 1 million gallon water tank, which was very, very expensive to install, 2 wells that are very expensive to drill, that Highlands arguably would be taking the position that now Mountain Green Mutual can't serve them, or is not able to get the exemption and would have to go the certificate of convenience and necessity and have the statement in there that somehow it's not encroaching on the existing service area. All these are interests that are very important to Mountain Green Mutual, and they need a seat at the table to establish the merits. The only other things that I would mention, because I know we've gone long here, is we've talked a lot, kind of forecasted what the merits discussion would be. And that in itself illustrates why intervention is appropriate, because all of these issues on the merits won't be adequately explored without Mountain Green and Village involved in the proceeding. And so, therefore, we would request that the intervention be granted, and we'd be able to have an evidentiary hearing in the future where we can present the evidence and ultimately where the boundary is set. That's an issue for the Public Service Commission to work through, but we need to have a seat at the table to make sure that it's an informed decision with all the relevant evidence. So unless there are any more questions, Your Honor, we would submit our petition.
I don't have any other questions, and I thank you very much, Mr. Jensen, for that succinct reply. And Ms. Smith, usually that's the end of the discussion. If you have anything else that you'd like to say that is very specific only to the legal interests as asserted by the petitioner, nothing else, I'd be okay with that. But if it's anything else, I'd like to just thank everybody for their time today and close the proceeding.
I just would like to make two comments on the comments that he just made.
Okay, let me again tell you that I'd like them to be only related to the very narrow issue, because if you do make a comment, I am going to give Mr. Jensen a chance, if he chooses, to respond, because he does get the last word.
Okay. I hope that what one is just they're both just clarifications. I think he was on the map saying that map 2A was the map that he showed with all the colors on it, that an area that we included in our service area that belongs to Mr. Johnson. The reason it's included in our service area is because we serve the customer that lives there. So that's why it's included, not trying. And the other was that his statement that we've been approached by Lee's Market, but Dwayne Johnson is a partner in Lee's Market. So
Okay, thank you very much. Mr. Jensen, as promised, you get the last word if you choose.
Nothing further, Your Honor.
Okay. All right, everybody, thank you very much for your presentations. Thanks for your preparation. A decision and an order will be made and issued in due course. So thanks a lot, everybody, for your time, and happy holidays.
Thank you, Your Honor.
Thank you. We're adjourned.
Thank you.